Oh, good. Okay. I'm pressing the blue go live button now. So,
click.
And we're live. It is Monday, April 5th, 7:02 p.m. Eastern Time and 4 p.m. Pacific Time. I am in Cape Cod. Ben is in DC. Mark is in, I'm assuming, still California.
Yep.
And we are not allowed to have fun anymore. But in lieu of fun, we had, I think, a really fun little day for internet decisions. And I'm so excited to have you on the show today, Mark, to talk about really everything that happened with the Oracle decision and copyright. But then maybe we can have some fun talking about the Thomas concurrence in the Knight case as well. I don't know if you saw that. So, yeah. How are you doing?
Good, good. Starting into my fourth quarter of Zoom teaching.
And how are you enjoying that?
You know, it's not nearly as bad as I thought it was going to be. The students are great. Everybody shows up. I still want when we go back to live, I want little name tags that float around in front of everyone you meet, like we have on Zoom. That would be awesome.
Can I say the one? Oh, go ahead, Ben.
No, please.
I was going to say that the one downside for me, and I'm teaching synchronistically in 2 different classrooms for a 70-person property class. So it's 35 students in each class. And I alternate between which room I'm teaching in, and the other room every week, trades off getting a video feed of me. And besides the kind of craziness of the tech issues that have happened, there is a marked, I saw one of my students pull down their mask to have a glass drink of water. And I was like, holy shit, you have a beard. I had no idea that this student had a beard. I actually viscerally just really was I have 3 more weeks to go of property and 26 classes. And this is the first time I'm seeing the student's face. And it's horrifying.
We have that in Zoom. I've had the opposite experience. So I do live office hours one-on-one if people want them outdoors. And one of the things I've learned is that I have apparently made mental predictions about how tall people are that bear no relationship to reality. Because all you get is a little head, right? And wow, this person is 6 inches taller than I thought they were.
I was hanging out with someone on a walk.
Just warning you, I'm short.
You are not that short, Ben.
I am very short.
You are? Have I forgotten that already?
Yes, you have forgotten
so
that.
much in my mind.
You have forgotten that I am short.
Oh my gosh. I had a friend say that that they had hired a bunch of people for a team and met with them in person for the first time after after hiring them and having never met them in person before. And they'd been working with them for 6 months. And they go, this is a really terrible thing to say, but I think I might hate short people, because they had already developed feelings about the people on their team. And it just turned out that all of the ones that they didn't like happened to be short. And so anyways, I just thought that was pretty funny. I was like, oh, I didn't even know that was a thing. Anyway, we are so excited to have you here. We're gonna try to have Jamil Jaffer to talk about the Knight Institute decision, but and join us and make it a little party. But he is having fun, as one should, and instead of in lieu of fun. But the rest of us are just stuck here, Mark. So nice to have you. Do you want to would you mind? I'm sure this is kind of above your pay grade, but if you would, do you mind giving a little introduction to the case and kind of how it worked its way up from the Northern District in California?
Sure. Yeah. All right. So, the technical issue in the case is Sun wrote Java, right, with this sort of a promise of write once, run anywhere. We'll create a sort of language/platform that allows you to use your code anywhere. Oracle, and it was open. Oracle then bought it. Oracle's about the least open company in the software world. They bought Sun. They said, well, yeah, you can use it, but subject to these restrictions, and you got to pay us a lot of money. Google, when it developed Android, decided not to pay Oracle and instead re-implemented the application's programming interfaces. So basically what that means is it took what it needed to take in order to make its programs compatible with Java. Java developers could use the same language and code to write for Android, and you could read files from previous Java.
Also, this is like, just to say that this is something that happens all the time, right? This is like, this is like a deeply, deeply like common practice in software development.
Right. This is right. This is how people. This is what people do with APIs, right? Right. Although I will note that Google, because it wrote its own code implementing these, it was backwards compatible with Java, but it wasn't sort of two-way compatible, right? So Google effectively forked the Java program.
I mean, you can kind of remember this from the days when, like, I forget what it was. I think it was iTunes. I'm gonna get this wrong, but just the general idea being like, there was, I think it was iTunes. It was like, it would take MP3s, but like you could not or like there was some type of thing that you could put everything into it, but it wasn't, oh no, it was just Word. Maybe it was just Word and like doc files and WordPerfect. That's what it was actually. It was like how WordPerfect did it with their doc file sharing.
And sorry, I think a lot of times you have a next gen file. That's what it does. So 25 years ago, the Supreme Court case presenting a very similar issue was Lotus versus Borland. And Lotus's 1-2-3 software spreadsheet. Borland wrote a sort of next generation spreadsheet with much better features, but they wanted to be able to have people migrate and use their existing Lotus spreadsheets, use their existing macros. So they took the menu command structure that allowed you to do that.
And capture that market and then not let them get them used to it and not have them leave.
Well, right, and so the First Circuit there said no, Borland can do that. That menu command structure is uncopyrightable. That went to the Supreme Court in 1996, and they deadlocked 4-4. And about that time, right, broad software copyright just kind of went away. People went the software patent route instead, and so we kind of sat there with that sort of unresolved issue, but with all the lower courts essentially having said these things aren't protectable. Quattro Pro was the Borland spreadsheet. And then sort of 20 years later, I felt like we're in this Back to the Future moment. So basically at the same time, the US Supreme Court wiped out a bunch of software patents in the Alice case. The Federal Circuit Court of Appeals brought back broad software copyright by holding that Oracle could go after Google for re-implementing the APIs. So
what did the court do today?
Right. So yeah. So the procedural history and what do we do today? So Oracle sues Google. District court says, hey, this stuff isn't copyrightable. Federal Circuit, which is the patent court, but which got this because there was a patent piece to it originally, reversed and said, no, it is copyrightable. Google tried to take that to the Supreme Court, but didn't succeed in part because the case wasn't over. Instead, it went back. They had a jury trial on fair use. The jury found that this was fair use. It was permissible for Google to do. Went to the Federal Circuit, and the Federal Circuit reversed and said, you know what? Actually, juries don't get to decide fair use, even though we sent it back for a jury trial on fair use. And we think this is not fair use as a matter of law. That's what went up to the Supreme Court today. And the Supreme Court said, well, you know what? Actually, we agree that juries pretty much don't get to decide fair use in most cases. It's ultimately a legal question. So this is a question of law, but we think it is legal as a matter of law, not illegal as a matter of law, for Google to do this, to re-implement the APIs in putting them into Android.
All right. So for those, I would say 80% of us who are lost at this point,
I've been trying to do a little translation of what Mark is saying in the chat.
Mark is translating, and I'm going to get him now to translate the translation.
Great.
What does it matter what the Supreme Court did. What in like we're kindergartners, what did the Supreme Court say today that matters for purposes of intellectual property law?
Yeah. So I'd say a couple of things, right? One, at the software world, as just mentioned earlier, this is how people do stuff a lot, right? And so one thing the court did, which is important, is to say, doing this is okay, right? That code is different. They expressly ducked the question, is an API or these kind of connecting interfaces that allow the programs to talk to each other the kind of thing you can copyright at all? But they said, even if we assume that you could copyright it, the fact that we're talking about this code that has very specific functions affects the fair use inquiry, and means that it should be entitled to less protection. There should be greater room for people to take this and reuse it in a productive way. And
so,
the courts, go ahead.
In other words, if you see something and you kind of reverse engineer how it happened, you can do that.
Right, and in fact, right, that's how we've done sort of a lot of software writing for a long period of time, right? So, and the court, I think the court focuses both on the fact that, hey, this is a kind of technical interface specification for software. This isn't Shakespeare or Mozart or something we give very broad copyright protection to, but also on the fact that Google has transformed it. That Google did copy a bunch of the particular lines of code, but it's not that it copied the whole program. In fact, 99+% of Google's program is its own code that it wrote. What it copied, the court says, were the things it needed to copy in order to sort of achieve this interoperability objective. And so the court's done a couple of things here, right? One is it says, interoperability is really important. That's actually an affirmative value that we want to encourage. So writing your program so that it'll kind of connect to previous ones is a good thing. And it is sort of, as a matter of copyright doctrine, said this idea that you've transformed something, that you've taken it and added to it, used it for a different purpose, made something new out of it, is a valuable and helpful thing that we want copyright to encourage.
But this wasn't an entirely policy-based decision. So no. That's the interesting part to me, is like they managed to actually thread the needle in a way that I think they should have with existing copyright law. It kind of is weird. There is a part of me that like wants to like hit myself in the head with a hammer every time it takes this long for the Supreme Court to hear one of these cases and for us to get these breakouts. Like I just kind of am like, oh, is that still a thing that we haven't decided yet? And it's like, so to kind of put a point on it, I want to hear about like kind of what your thoughts are about like what the motivations of the court were. And as like, you know, as someone who is so read into the copyright doctrine, you are allowed to get into the weeds a little bit on this, obviously, but also just like for the cohesiveness, like things like deciding that like the jury trial was such like, I mean, that is like a huge deal. If you're trying to basically have these huge, very highly monetized, very lucrative suits against companies, the prospect of a jury trial versus a bench trial is two very different things, especially depending on which judge you end up getting. And so there are, I just am curious about that. And then I'm really just, I don't know, like, well, I would like to end up at some point in the discussion, a conversation about whether you think it's maybe time for some type of specialized court for like anything, for some of these tech issues. I just think Judge Alex there's one of him and there's the rest of the, and they're not all like that bad. Like they're not terrible, but do you see what I'm saying? Just kind of, yeah.
Right. Also, I hear you, right? And like Judge Alsup was quite remarkable in this case, not least because he basically went and taught himself programming in order to understand the technology of the case, which is a pretty impressive thing to do. I will note, for what it's worth, that this case, because it had the patent piece, went to the appellate court that we have, that is a specialized court that deals with tech issues to some extent. And, from my perspective, they got it wrong twice. So, you pay your money, you take your chances, right?
You'd kind of rather have the judge who teaches himself programming in order to hear the case than the specialized court that doesn't bother.
Yeah, I hear you. Right. Yeah, I think that's right. And I mean, look, there were plausible legal arguments on both sides. I mean, I think the Supreme Court got it right. I think the Court of Appeals got it wrong. But it's not that Oracle had no arguments in its favor. So I think one of the interesting things that the court did, as Kate says, as a policy matter, basically approving the way we've been kind of dealing with software for the last several decades was a good thing. A lot of people, a lot of companies, a lot of computer scientists, showed up as an amicus and said, "Hey, please don't screw this up." Right? If you rule for Oracle, you're going to fundamentally change the way we do things. And I think that probably resonated a bit. But as a doctrinal matter, one of the most interesting things, one interesting thing is the jury question, right? And so the court does seem actually less willing to sort of to have juries in this area. But the other thing they did as a doctrinal matter that I thought was important was this focus on transformative use. So this is an idea that's been around for maybe 30 years, that, the key to thinking about whether a use is fair should be, am I changing it, transforming it in some way that either makes it a new thing, adds to it, or uses it for a completely different purpose in a different direction. There was a sort of offhand reference in the last Supreme Court fair use case back in 1994 to transformative use. And then based on that, a bunch of the courts of appeals ran with it, and transformative use kind of became the thing in fair use doctrine. But in the last year or two, we've actually seen courts pushing back against it and saying, well, you know what, maybe transformative use isn't so important. It shouldn't be everything. Maybe we got to focus more on the market effect and think less about transformation, and also narrowing the idea of what a transformation of a work could be. And one of the things I think this court does that's going to be really important is it does make transformative use a centerpiece of the fair use analysis, right? It focuses very directly, very clearly on it. And just one case to note that has nothing to do with software, which might help your audience, some members of the audience be happy. Last week, the Second Circuit held that Andy Warhol is a copyright infringer. And the case involved his depiction of the artist Prince. But in fact, the argument essentially would have applied to pretty much everything Andy Warhol did. And it basically said, we don't think Warhol's transforming photographs. He's just sort of coloring them in. And in any event, we don't think transformative use is all that important. I think that opinion is in serious trouble after the Google
clearly
today. And for good reason. So I think it's going to have effects not just in software, but it's going to have effects in sort of the rest of copyright law.
Yeah. So, I mean, were people seriously worried, Mark, that this was going to come out the other way? I mean, the last I checked in, every single person I knew in IP had signed on to one or another brief that was basically begging this result, or a result similar to this. And like, is there one particular set of briefs that won out over another, or was it a mix of all of them?
I mean, who knows? I mean, there are a number of the briefs actually get cited in the court's opinion, but I think it did have an effect on the court that, right, sort of professors from all over, computer scientists from all over, industry folks from all over came in and said, hey, don't mess this up. But I'll tell you, most of us kind of thought we were going to mess it up.
Wait, you thought that the court was going to mess it up? Yeah.
So what would be the consequence of a decision affirming the Court of Appeals on this? If the decision had gone Oracle's way, what does the world look like?
Right. Well, I mean, so one consequence, probably the least important in the overall thing, is Google would have paid somewhere between $8 and $20 billion.
So what?
Right.
I mean,
That's why they're there, right?
That's why they're there.
I don't care about that. That's merely one set of shareholders wins at the expense of another, and so how does the world look different other than the shareholders of Google and Oracle?
I think the answer to that is that it would have put a nail in the coffin of the idea of interoperability. So internet is based on interoperability, right? If I want to sort of add a program to my computer, I can sort of pull it down from anywhere. In the 80s and the 90s, right, we had a very strong kind of norm of interoperability. I think in the last 20 years or so, we have, in part for technical reasons, in part for legal reasons, sort of increasingly replaced that with walled gardens. Right. So if you want to load a program on your iPhone, well, you got to go through the App Store. You got to get Apple's permission. Apple may deny that permission or make it harder, especially if it competes with an app they provide. Even if you want to go outside the App Store and sort of visit something on the internet, well, you got to go through their browser, or at least through the internal workings on the phone that use the Safari browser. Right. And so this idea that sort of, hey, we've built platforms and anybody can attach anything they want to those platforms, I think has been fading for a while. And that's a bad thing, in my view, right? Because
no, totally. And this is
one of the things it leads to are these sort of dominant gatekeepers, right? Platforms that basically get to decide what comes on, what doesn't, and therefore get to decide what potentially competes with us and what doesn't, right? What things might displace us and which don't. And I think if the case had been decided for Oracle, it would have really cemented the idea that you don't get to write a program using what Cory Doctorow calls adversarial interoperability. I want my program to work with yours, even though you don't want me to. And I think it's much harder to break the stranglehold of those platforms in a world where nobody gets to do that.
Yeah, I think that this is such a wonderful point, and I think that it is. I think we're going to be entering a world in 20 years. Hey, Genevieve.
Hi.
1 second. And then we're going to be like entering a world in like the next 20 years where like I'm explaining what APIs are, and I don't think anyone in the audience is stupid or ignorant for not knowing that. They just haven't been exposed to it. And I think we're entering a world in which this type of language and this type of talking about things is going to be as ubiquitous as about talking about font size or various types of like other things that we have that allow for, or like different plugs on our computers or things like that, like different USB standards. So I think that this is kind of one of these things that it strikes me as shockingly an obvious policy decision, unclear how they were going to thread it with existing doctrine. And then I'm pretty happy with the result, but I still just like, there is part of me that feels like this was just the sword of Damocles that could have killed, like in so many ways, like parts of technology and the internet. And I also mean that in like kind of the old-timey sense of like, who cares about the sword of Damocles? Like it's this like thing that like is like this old reference. Like, why are we even still talking about a 10-year-old case? But that they could have brought it down, even though it was like 10 years old. And I think that was just so jarring for me and like what that would have meant. So what do you think this means for copyright kind of going forward? And then we're gonna kind of start going to questions.
Yeah. So I mean, I do think it's encouraging that the court sort of viewed this as something where they understood that there's an affirmative policy and a benefit to using somebody else's work for a different purpose to transform it to achieve interoperability. The court's last foray into copyright law in the Star Athletica case was not particularly encouraging, right? And so I think the fact that it came out the way it did, but also the fact that it was 6-2 is a good thing, right? All right, so you've got Breyer and the liberals, but pick up Roberts and Gorsuch and Kavanaugh, and that suggests that this is not a political issue, which I think is nice. And I think that
was super nice, actually. I actually think that's really a lot bigger than people are talking about. I haven't seen many people make that point. But the non-political nature of it is so important, because I think that there is a real intellectual and policy imperative here.
And it's interesting to note. I love Justice Ginsburg in all kinds of ways, but she was very, very strongly pro-copyright owner, in part because her daughter teaches copyright at Columbia and is very strongly pro-copyright. So she was not she would have been writing the dissent on the other side if she were around today, probably.
Yeah, all right. Certainly. So we are hereby, by the decree of the hosts, launching a new feature on In Lieu of Fun, of which Genevieve de la Fera is completely unaware, but is our guinea pig. So for a while, you may have noticed, I have occasionally been bringing in people for a string of questions when they post multiple good questions. And we thought we would institutionalize that and just turn over a portion of the show to a member of the Greek chorus who posts a interesting string of questions. So in this case, that would be Genevieve. So Genevieve, the floor is yours until you give it up.
I feel very unprepared.
No, you can just ask some questions. They were all really lovely.
Just have a dialogue with the guest.
Yeah,
we will sit back and see what happens. And if you abuse it, we'll make you disappear. But as long as it's interesting, we're just going to keep it going.
Okay.
I can cancel you at any moment, Genevieve.
Yeah, it's cancel culture.
It seems very fair. I will not abuse the power. Hello, and thank you. So I had a quick question regarding if you had any concerns about the court's opinion regarding the new judicial review of fair use after a jury finding of fair use. It seemed slightly conclusory to me in the opinion, and I think that Justice Breyer actually did acknowledge that there are some substantive issues of fact that will underline the question of law. So I don't know how you can distinguish between the two.
Yeah, so this is a hard problem, and it's actually something that we've been dealing with a lot in patent law, right, which I spend some time on, right, because we've got a bunch of doctrines that fit in this. Well, the ultimate question is a legal question, but there's subsidiary fact questions, and the court's all over the map in how it deals with it. I think one of the weird anomalies in this case was that the Federal Circuit literally in 2016 sent it back to the district court to have a jury trial on fair use.
And did they say jury trial, or did they say finding it back?
They said jury trial on fair use. They got it back in 2018, and they said, well, the law's changed in the interim. There was a non-IP case from the Supreme Court in 2017 that talks about the law-fact distinction and what juries can try. And on the basis of that, we think, no, you know what, actually, this is something where the questions that predominate are really legal and policy questions, not fact questions. And so even though you might want to resolve subsidiary fact questions in front of a jury, the ultimate decision shouldn't be handed to the jury. So I think that's really interesting. I think that's something that a number of people have been pushing for the court to do in patent cases and in the obviousness law, in patentable subject matter, right? There are a bunch of doctrines that look like this in patent law, and the Federal Circuit has been very reluctant to do that in patent cases. So it was very interesting that it did it here. And then Google didn't actually appeal on that ground originally, and the Supreme Court asked the parties to brief this question. Part of we sat on this for another year over COVID was like, while we're sitting on it, hey, give us briefing on the question of whether this should be a jury question at all. Then they end up affirming on that basis. I do think it's going to mean a lot fewer jury trials there aren't many jury trials to begin with on fair use, but now my guess is you ought to have maybe an advisory jury at most. You ought to have a jury trial that just asks them fact questions like, right? Was there a licensing market that would have been disrupted here, right? Did this interfere with sales? Those Justice Breyer seems to focus on as factual questions that'll inform the inquiry.
It did seem like there was a lot of focus on the market. Sorry.
Yeah, no, a lot of focus on the market. There was a lot of that in this. But really quickly, Mark, I have a question. Do you think this is going to translate into other areas that are more kind of typically like jury trial or survey based? Like I'm just thinking like likelihoodness of confusion and trademark, or if there's going to be any type of corollary into other areas of IP. Or I mean, like the fair use jury trial is its own thing. But this seems like I'm just wondering if you think it has any other.
I mean, I do. I think it ought to translate into obviousness in patent law, for instance, right? I mean, Supreme Court said in KSR that obviousness looks just like this, right? It's an ultimate question of law for which there's subsidiary questions of fact. Nonetheless, we almost always just hand the jury the question of obviousness. The Northern District of California, interestingly, is an exception. They offer either the idea of an advisory jury or a jury that answers specific subsidiary factual questions, right? Was this invention commercially successful? Was there a long felt need for the invention? And I think that approach is probably, that's probably a good one. Rather than just plaintiff wins, defendant wins, let's actually get them to decide the questions they're supposed to be deciding, which are fact questions. And leave the overarching policy issues for the courts.
I have a quick question on that, though, because in this particular case,
it doesn't have to be quick.
They weren't overly concerned about the constitutional implications of that. But if you start to cabin issues with a jury, do you think that could raise other more bigger issues regarding the trial by your peers, or?
So, I mean, I think on criminal cases, there's definitely going to be a set of issues, right? But even on civil cases, the court has long distinguished on Seventh Amendment grounds a couple of things, right? One is law versus fact, but the other is what did we do in England in 1791? And so I did actually do some investigation of this around the patent side issues. The problem we have is there wasn't really a fair use doctrine at all in copyright law in 1791, right? And so, but I think that's given the court in the past some freedom to say, we can characterize this as either a legal question, in which case we're going to give it to the court, or as a jury question, a fact question, in which case we're going to give it to the jury. The single greatest example there is the Markman hearing in patent law, right? Where the court said, hey, construing patent claims, figuring out what patent claims mean, just wasn't something we did in 1791. And so it's not something for which there was an established practice that we have to preserve under the Seventh Amendment. And so we look at this and we're like, yeah, you know what? This looks like construing other legal documents. It looks like statutory interpretation, or it looks like contract interpretation. And judges do that stuff. So we think this is the sort of thing that should be done by courts, not by juries. Fair use to me is not as close. It is a closer case than that, right? Because there are these subsidiary fact questions, and they may matter a lot in particular cases. But I do think there is a worry that if you just say, here's 4 complicated factors that interrelate and have sub-factors and make a judgment, jury go, right? We end up with these black box verdicts that might not necessarily map well to good policy. Okay.
Well, thank you very much. You guys kind of touched on my question about policy and the opinion earlier, so I don't want to be repetitive. So I see the rest of my time, but thank you very much.
All right.
Genevieve, I'm so proud.
I'm so awkward.
Mark, Genevieve is one of my property students from last year in the pandemic, and she had to live through me teaching landlord-tenant law, one half of it in person and one half of it in Zoom University, and made it out okay, apparently, and has been taking intellectual property. I had no idea. So this is wonderful, and I'm so glad to see you, Genevieve. It's really lovely.
Thank you. It got very real very quick.
Yeah, I know. So, I mean, that was a fascinating question. Also a fascinating question about juries and obviousness. And I think that is, I really do wonder what reasonableness standards, juries, like all of these things would how they would fold if we sent more of these cases to juries. And I think that we judges would rely on them so much less if there wasn't an elite decision maker in the position of judging reasonableness. And that's like a legal philosophy view of mine. But yeah, this kind of is one of these moments where I'm reminded of kind of the ramifications of that kind of stuff. So we have Richard. Richard, hello. Hi, Richard.
How are you?
You have a bunch of great questions. It's so nice to see you.
I still can't believe, Richard, that you're a Bruckner guy. It's just
man,
been bothering me.
This is really eating you up.
Four people know what you're talking about.
Oh man. You'll come around one day.
It's not going to happen.
So, well, there's the famous Virgil Thompson review of one of the Bruckner symphonies where he says, "Major chord is a major chord is a major chord is a major chord." So Bruckner is known for being repetitive. He's really
and long
and long.
I forget who said life is short, but Wagner is long. I thought it was unfair to Wagner, but perfectly descriptive of Bruckner.
Well, Bruckner is about slow change and stasis. And yes, it is slow and static.
Yeah.
So,
meanwhile, back in the world of intellectual property.
Yes, this is really fascinating. And I've been fascinated with intellectual property for a long time, not just because of music, but also because I did work as a software developer for a long time. And so one of the things that I was thinking of is, one of the weeder questions that we would use in interviews is we would ask developers what an interface is, and we were really surprised how many people couldn't answer that, which made it really easy to weed them out. And so I guess people in the Greek chorus who don't understand what's going on don't feel too bad about it. But I guess, and so that.
If you're about to ask me what an interface is, I'm just going to make it clear that I'm going to call on Genevieve to answer.
Yeah, how do you like it now, Genevieve?
So I guess my question really links up with that, and that's in the path of this case through the courts, how much was affected by the justices, or the judges on the way up to the Supreme Court, understanding or not understanding, like the interface and an implementation and very basic things like that?
Yeah, it's hard to know. I mean, I do think so. There's been a little bit of discussion of this. Judge Alsup really did, to a greater extent than sort of pretty much any judge in any case, dig in and learn this stuff, right? He really wanted to understand it, which is great. But I don't think it's, as I said, I disagree with the Federal Circuit, but I don't think they kind of fundamentally misunderstood the interface issues necessarily. I think the one issue that where they just sort of went off in a kind of sideways direction, Oracle, I think, correctly pointed out that this, what Google was building was not sort of full compatibility between these systems, right? They were forking the system. And I think they managed to persuade the Court of Appeals that therefore this case had nothing to do with interoperability, and you could ignore all of the interoperability case law in the Ninth Circuit. You could ignore the sort of policy concerns about this. And I don't think that follows. I think it's sort of closer to sort of backwards compatibility, right? Which we might still find desirable, even though we're sort of generating a new thing. And one of the things that's remarkable to me is if you read the Justice Breyer opinion, there is a long and detailed disquisition into the software, which seems to me pretty good, actually, right? So either he or his clerks, right, delved into this enough to actually really understand how it worked. He couldn't resist being Justice Breyer a sort of like random far-fetched analogy in the middle of the discussion, but I thought they did a lot better than I would have expected or feared judges to do, I guess.
Yeah.
Great.
Thank you,
Thanks.
Richard. Yeah, I'm very, so now we have, I'm not going to exercise the full, well, first of all, because I only know him by his handle, but Oxjoman's full kind of capacity, but he has a number of great questions. I only know it's a he because he briefly popped up on screen, but I think he is now in the dark. Oxman, if you're ready, I'm just going to unmute you. Go ahead and ask your question.
Thanks. Well, I'm getting some echo. First question is, how does this decision affect the patentability of code, or I guess implementations of algorithms, or organizational choices of like API prototypes, or the prototypes themselves?
Great question.
Yeah, fair question. So first off, let me do the sort of IP lawyer thing we always have to do, right? Sort of distinguish patent from copyright. So I don't think it has any play on the patent questions per se, though that's separately issued. On the copyright piece, the court ducks the question. So a lot of the debate and some of the amicus briefs basically said, you know what, copyright just shouldn't extend to these very functional pieces that you need to have in order to sort of make these things work. The Court of Appeals had originally rejected that, and the Supreme Court says we're not going to resolve that issue. Justice Thomas's dissent, I think, kind of tries to take them to task for that, although not so successfully in my view. Justice Thomas clearly thought, hey, this is copyrightable. But I think even if you think this is copyrightable, it's perfectly reasonable to find the fair use the way Justice Breyer did. I also think, I think for what it's worth, if the majority, certainly if Justice Breyer had to confront the issue, and probably if the majority had to confront the issue, they would have said, this isn't the sort of thing that's copyrightable at all. But I think they rightly concluded, we don't have to confront that issue, and we can make a narrower ruling that says it's okay to use this code for this purpose and not resolve the question that might end up screwing up something we haven't thought about, right? Which is, can we copyright interfaces at all?
Yeah. I don't know what to call you, so I'm going to keep calling you Oxman, even though I think it's a zero. So
It's a zero.
Yeah, what do you
what
go
would you
by?
like us to call you, Oxjoman?
You can call me Oxjoman, but
I'll call you Oxjoman. Great, perfect. That's fantastic. It's nice to have you on
Look,
screen.
we call what's his name
Big
the
Blue Blogger.
Blogger.
Yeah.
Even though we know sometimes we just call him Big Blue.
Internet
so
be weird.
You can go by Oxjoman if you want.
So now you're basically stuck with it forever. I know that Ox means binary, Alice. I'm just reading it like a name. Jeez. Anyway.
Alice, you don't have to pronounce it in live.
I know.
It's different
Anyway.
when you actually have to pronounce it.
So I wanted to actually get to your second question, because I thought that it was great about the legal distinction and between programming languages. So can you just talk about that? You can ask that question really quickly.
Sure. Yeah. As a programmer, I think I can draw a distinction between the language used to write a program, and those are kind of like the tokens and the grammar required to implement some algorithm, versus the APIs, which are like interfaces, which kind of like what I guess Justice Thomas wrote, are kind of pointers to larger pieces of code that are implemented elsewhere. Do you think there could be a legal distinction drawn between these two things, similar how I've done it?
Yeah, absolutely. And there was actually a debate in the Lotus versus Borland case about whether languages could be computer languages could be copyrightable, right? That we then sort of lost as people just kind of the industry just went on. So I definitely think you could draw that distinction. I think it's much harder to say the actual sort of interconnect pieces should be copyrightable, it's more plausible to say, the Java programming language should be copyrightable. If you, I think sort of even if you say that, you might nonetheless want to permit sort of people to copy some of that for some purposes. One difference that maybe is worth thinking about and that gets a little bit kind of conflated together in the court's opinion is the, can I make these things work together, the pure API piece, and can I use all of the knowledge, programming tools, etc., that I have developed in language 1 to implement in Android instead, right? And this similar thing came up in the Lotus versus Borland case. It wasn't just I wanted to be able to move my spreadsheets out of Lotus to this better program. I wanted to be able to use the coding that I had written in Lotus 1, 2, 3 and apply it here in Quattro Pro. And so I think something similar is going on here, right, where the court's interested not just in protecting the ability for these things to interoperate and communicate, but also the ability for developers who've written macros or programs in a particular language to apply those on Android.
Yeah, that was, yeah. McCoy Smith, so nice to see you. I don't think we've ever had you on before.
No, I'm new.
I like your glasses. Please.
Well, welcome.
Yes, welcome to In Lieu of Fun.
And to all of you out there who have never allowed us to rapture you in to ask a question, and that is the majority of you. McCoy Smith is a model for you all, whom you should emulate in life in all things.
Yes, great.
So in other words,
you didn't know that when you
ask a question.
Yes, go ahead.
For God's sake, when you put your question in the ask a question box and Kate raptures you in, don't reject it. Actually, let us rapture you in. The worst that'll happen is we'll make fun of you like we did with Daniel and others.
I had to rush to put on a shirt, but otherwise, yeah, I'm good. So
great problem.
I'm a lawyer in private practice in intellectual property law, as well as sort of a quasi-academic. I did have a question. I'm picking through the decision right now, and one of the parts of it that gave me a little bit of pause in the advice I'm necessarily going to have to give clients over the next couple of weeks is the market effects portion of the agreement, or excuse me, the decision. And the question was, well, if you change the facts a little and Oracle or Sun had a smartphone version of Java available at the time, so there was an actual market competition between what Google was doing with Android and what Sun Oracle had in place, do we get a different decision?
Yeah, that's a hard question. And right, because the court does.
Great question. This is why I brought you in. Thank you for asking this. Sorry. I was like excited.
So I'm glad you're happy that you let me in.
I think the court does definitely focus on the fact that there wasn't a direct market impact, right? That Sun wasn't launching a mobile phone, that this wasn't something where you were displacing the market for the mobile phone. I think if you buy the interoperability story, then the sort of second part of the market analysis that the court engages in, where it says, hey, look, one question is, did you lose anything? But a second question is, if you did lose, why did you lose that thing? There, I think the court views you lost because someone engaged in legitimate competition and people like the other product better as not something fair use should take into account as a market harm. Now, there's a little bit of circularity here, as there is to pretty much all of the market harm inquiry, right? But if they've concluded that what you've done is sort of transformative and ought to be legally permissible, and the harm that has been suffered is, hey, because I made this transformative, valuable product, you had to compete in a market when you otherwise wouldn't have had. I don't think they view that as market harm. They don't really have to come out and say that as explicitly, because there is the jury finding that there just wasn't, there was no market here, right? We weren't in that business. It's harder to come to that conclusion. The reason I am sort of cautiously of the view that the court would still come to that conclusion, that they're pointing in that direction, is they talk about the Sega versus Accolade and Sony versus Connectix cases, right? These are the cases where the Ninth Circuit allowed adversarial interoperability and copyright in the video game markets. So I want to write a video. I've written a video game for the Nintendo platform. Nintendo's out. Sega is the new thing. I want to port my game so that it can run on Sega. Sega doesn't want me to. And it's probably right that Sega loses sales of its video games if people buy my competing one instead. But the court says that doesn't count, right? Because the harm that you are suffering is the harm from competition by an independent video game, not the harm from
the corporation, or from the corporation, or from, is it a harm from the corporation? Or is it an actor instituting a harm, or is it just the harm from the video game as a product?
It's a harm from the video game as a product and from market competition from this independent thing, right? So I think if it's, in Sega, for instance, the court looks at this and says, hey, wait a minute. Yes, it's true that if I couldn't reverse engineer to sort of make my product compatible with yours, I wouldn't have been able to sell this game to people who use the Sega platform. But the loss that Sega is suffering if they don't sell some other game is that game lost out in a head-to-head competition with my game, and my game was an independent thing that I wrote. And so I think the court looks at it that way, and I think they'd say the same thing with respect to Android, which is, hey, if people like the Android phone better than the hypothetical Sun phone, that's...
What is this going to say for Google versus Bing?
Google versus Bing?
Yeah, I just kind of think that you present another product that is the only other sale, possible product, or is there going to be, you try to create some type of other search engine and you put everything behind I'm just kind of curious. Maybe my brain is skipping ahead a few beats and I'm not explaining myself well, but when you're saying the Android versus Sun, that's one thing, but what if it's the Android versus iPhone? And what if Android wasn't a market share? What if it was more like something that it was like Microsoft Bing, which had Microsoft behind it, but Bing completely failed epically, right? And then you have Google. In Google search. I should say specifically Google search. So I'm just kind of it's not clear to me yet, how this is going to mash up onto, this decision is going to mash up onto something like that. That's kind of what I meant when I said Google versus Bing. Sorry, maybe I'm getting ahead of myself, but we have one last question, and it is from Daniel, who I have no idea where he is. Oh, Daniel, you're leaning back in your chair comfortably.
Whoa, wait a minute. There was a pillow. The pillow disappeared and you changed orientation. Everyone saw it. The pillow was not your native habitat. It was kind of checkered. How did you make yourself change like that?
I can walk.
No, but you just reappeared in a different location.
I think that there was
a latency.
There was a latency issue. I think that's all.
Okay.
Because Daniel, watch it on the YouTube replay, and you'll see you just magically transformed.
Daniel, the floor is yours.
So I have a 30,000-foot question, and take it in any general direction you would like. If you had the power to rewrite copyright law, what are the first 3 changes you would make?
Oh man, yeah, nobody's going to give me that power, sadly. So that's a good question.
We can convey it on In Lieu of Fun.
Excellent.
as a like party favor for showing up.
I appreciate that. So first thing I would do is I would make copyright a lot shorter than it is. The idea that sort of we need the protection for the life of the author plus 70 years, no matter what it is, seems crazy to me. I would probably, the second change I would make, I actually have a paper on this that I'm happy to send a link to that just written. I would make it permissible to copy something when it's disappeared from the market. So, you know, we have this, for a while, we've had this idea of out of print books and whatnot. But you know, even if a book's out of print, you can find it in a used bookstore, maybe you can find it in a library. What we're seeing in the modern streaming world is a bunch of content that just disappears. Now, we're not all the way to streaming, and so there are still sometimes the DVDs you could find, maybe, right, or circumstances in which you could download something. But increasingly, you know, Netflix has gone from a library that 100,000 movies in it when it was mailing people DVDs, right, to something like 3,000 or 4,000. Some of that stuff is available elsewhere, but a lot of that stuff is just gone. So I would say we ought to have a rule that if you sort of if you aren't providing the publicly available information anymore, somebody else is free to do so.
Les, I love that idea. Like, I think that's a wonderful like idea. You can call it the Lemley doctrine.
So the paper, if you were interested, is called Disappearing Content, and you can search for it at least until it disappears online.
We are going to leave it there. Mark Lemley, you're a great American, and it's been a pleasure seeing you again. And we haven't even talked about video games today.
We haven't.
I just sold my Oculus.
Didn't like it.
We'll talk about it later.
I mean, did you even ever try Supernatural? We got to have the people who designed Supernatural on the show to talk about this, because I think this is the future of workouts, and I am. I think it is really, but that's a different day for a different conversation for a different day.
We're gonna have you on soon. Again,
we will be back tomorrow with Julia Angwin. What are we talking about with Julia?
I don't know, about the markup, I think, and about like kind of like they've been running for a year and a half, and they just bought office space or leased office space a week before they went into the pandemic. And like, I think that there has been considerable kind of craziness in starting up a new investigative tech privacy journalistic output. So I think I'm just really excited to talk to her about that.
And that will be tomorrow. And then on Wednesday, we have Chuck Rosenberg coming on to talk about his new Washington Post article that was posted, I think, while we were talking.
Wow, cool.
About the FBI's performance on January 6th, which is, as you all know, a subject near and dear to my heart. Anyway, that will all start 21 hours and no minutes from now.
I'm so grateful to you for doing the math.
For being able to subtract 3 from 24.
Sorry, it's not that
I can subtract. And until then, we don't have fun anymore. But we do have, ladies and gentlemen, a Supreme Court that can still resolve copyright issues without lurching to partisan camps. And that's pretty cool.
Yeah, it was pretty good. Thank you so much, Mark. This was so lovely. It's great to talk to you as always. This was wonderful.